The midterm is an interesting experiment, right? We're starting it this semester. This is kind of a new deal. And the reason why we're doing it is because we want to get a test of where you are. So, you know, I didn't quite know what to expect. I was a little disappointed, and I'll be honest. And it's your own fault that I'm disappointed because I had really high expectations. You're a very good class, and I've complimented you on that a number of times. And the papers weren't where I expected them to be. I expected more. And I suppose that's a compliment that I think highly of you, but it's not because it didn't quite meet my expectations. So I have here the distribution of the grades. And you'll see that the mean is about a 298. Usually in ConLaw for the final, the mean is around a 311 or 310. You may not even know this, but as professors, we have a range, right? I can't give whatever scores I want. The average must be between 285 and 315. That's our range. So I actually give closer to the high end. I couldn't do that this go around because the papers just weren't there. Also, there were not nearly as many A's as I usually give. There were a lot more B's. No one failed, but there were some papers at the bottom of the spectrum. So what does this mean? You're going to do better. Right? Why do I know this? Because you only learned half the material, and now you have an experience under your belt of taking this midterm. I'm sure you learned a lot, and you'll profit from it. Second, if nothing else, I know now, or actually I don't know who, but I know now that there are some students who aren't doing as well. I want you to come talk to me. So the way this works, if you got a C- or lower, you're obligated to, you're required to email me. I can't force you to come see me, but I would make that request in the strongest of terms. If you did better than that, you're welcome to come make an appointment with me. Already a handful of you have. I'm pretty flexible with timings. I know you have various time constraints, but I do want to meet with you. Also, I hustled last weekend to grade them very quickly. I graded all my property and ConLaw ones in one weekend. I did nothing but do this. My eyes were bleeding by the end of it. But I did this deliberately so that you'd have these scores early on, and you could actually like come talk to me about it and say, oh, yeah, remember that question about whatever about Washington and how it'll be fresh in your minds, right? So I want you to do better. I want to help you do better. If you didn't do well, it's okay. This won't count for anything. No one's final grade will be impacted by it. Hopefully for the final exam, we'll get the average up. I mean, everyone can't get an A, and it's frankly impossible to get that given the curve. But there can be a lot more B's, and that's what a class should shoot for. I don't mind giving at the high end. You can see what I gave last semester. I mean, I gave like a 312 or 313. I don't mind going high when the class performs, but I want you to perform that level. I don't just hand out easy grades. I want to make sure if I get someone an A, that means that they're a top student. In terms of specifics, I put a few. Oh, by the way, you can download the exam, and the A+ paper is also there, so you know effectively what you're trying to achieve. You can look at the paper. One note, and I can't say this any more clearly, what I don't want you to do is come to me and say, well, professor, this guy got an A+, and I wrote this. I wrote the same thing. Give me more points. Never, ever, ever do that. Ever, ever. And I'll tell you why. As professors, we have no discretion to change grades. This may seem striking to you, right? But if I want to change a student's grades, I need to write a letter to a committee of like 8 professors, and they need to vote on it. And then the faculty needs to vote on it, okay? We don't change grades very often. I've changed a grade once, and that was due to an Excel error. What happened was there were 2 columns. It should have added the sum of column A and column B. For whatever reason, the spreadsheet, probably my fault, didn't add it. So instead of getting like an 83, he just got a 40, right? So he got a C. He walks in, he's like, well, professor, I got a C. I'm like, wow, let me look at your paper. He's like, that's not right. So I realized I made a mathematical error. That's the only change I can make. So when you start arguing, saying, oh, I should have more points there, you're digging a hole. It's petty, and it doesn't make you look good. It happens every year. A couple people come by. Don't do it. Not just for me, but other professors. It doesn't work. And also, it amounts to effectively an attack on my grading, not what you're trying to do, because it's challenging my judgment calls. Learn, right? How can you do better? What did you miss? What could you include? Don't quibble over points. It's such a. I think I tried doing it once in law school, and I realized very quickly it was stupid. Never did it again. I got a C+ in torts my first semester. It happens. You get bad grades once in a while. So In terms of specifics, the case itself, the fact pattern was based largely on Zivotofsky. And the fact is I made the time period 1789, which means you don't have cases to cite. What I wanted you to do at every juncture, what I forced you to do was to look at the original Constitution. What is the text? What are the practices at the founding, right? What were the understandings? We went through this in Zivotofsky in painstaking detail. So you should have been familiar with this. So if it's a question about the recognition power, you need to know, okay, this is based on the Reception of Ambassadors Clause, the appointment of ambassadors. Like, there are different clauses we discussed. You need to know whether this power is exclusive, right? What are Congress's powers over recognition? You need to talk about the the appointment and the removal power. Again, we don't have Humphrey executives. We don't have Myers. We don't have Noel Canning. These are 200 years into the future. So you need to actually talk about things like the advise and consent clause. Now, there's nothing in the Constitution attached to the removal. You could also make an argument that, well, we shouldn't force the president to employ someone he doesn't like because that frustrates him from taking care of the laws to faithfully execute it, right? There are these arguments that are, I don't want to say buried, but they're the principles in the cases we studied without the case itself. And that's what I'm trying to extract from your minds. We had a question about the recess power, right? The recess appointment clause in the Constitution. How long has the recess have to be? Is it a recess during the session or after the session, right? The last question on the war powers, again, is there actually a requirement in the Constitution for the president to have a declaration of war? Not entirely clear. One point I want to stress is I would accept answers going either way. If you said the president has the power, if you say it doesn't have the power, I don't really care which way you argue, so long as you do so persuasively, which is what I'm trying to test you on. And again, I encourage you, especially if you are on the lower end of the spectrum, come talk to me. Let's figure this out now and not in December when you're panicking, saying, oh my God, what am I going to do? Like, if you come to me in December and I've never seen you before, I can't help you. Every year this happens, right? Or more than one, though. Not tonight, since more than one else, right? They'll come to me like the week before the final. I've never seen them before outside of class. I don't know anything about them. I was like, Professor, can you help me study? Like, you know, are my notes okay? And that's not what you do. Do this earlier. We can't help you once it metastasizes the last week of the semester. Then it's out of our hands. All right. Any questions? Anything on your minds? Yes, sir. Oh, it's on the class blog. Yeah. I always post my distributions because I want my classes to see a sense of how they rank against their peers. I think it's helpful, and it's especially helpful for a midterm, so that way you can kind of figure out where you stand in the class. Other questions? Anything else? Okay. All right, let's start. So in our last class, we studied what I call the segregation cases, so to speak, right? We studied Dred Scott, we studied Plessy versus Ferguson, and we studied these decisions where the Supreme Court effectively, the Reconstruction Amendments, a dead letter. We had Dred Scott, we had a bloody civil war, we had a Reconstruction Congress that passed various laws and indeed proposed amendments. One would think reverse the effects of Dred Scott at a minimum. But in the decision of Plessy versus Ferguson, and really the civil rights cases some years before, the Supreme Court blinked. They said that under the 14th Amendment, there's no actual guarantee of equality of the races. And so long as accommodations are equal, they can be separate. Again, these cases it was 1896, so roughly 3 decades after the 14th Amendment was ratified. The 14th Amendment was reduced to a dead letter. And I don't say that lightly, but for all intents and purposes, with the exception of the eradication of slavery, certain states in the South were not much different in 1900 than they were before the Civil War. Through the regime of Jim Crow, states were effectively able to resurrect almost every aspect of servitude, short of the shackles themselves. Okay. So, yes, Michelle.
I'm sorry. And you said, do we have any questions? I thought you were still talking about the exam.
Oh.
Do you mind just differentiating for me what the court in Plessy versus Ferguson, the difference between a political versus a social right?
Okay. So Michelle's question is this. The Plessy court had a precedent they had to deal with. Strouder versus West Virginia. You will recall this case held that the state of West Virginia cannot pass a law excluding blacks from jury duty. Remember this case? So they couldn't overturn that case, right? They already held that things like jury duty, you cannot have segregation. So they crafted this distinction, which actually was a meaningful distinction, but not in this context, between a political right and a social right. Political rights concern rights vis-a-vis the government. In other words, what stuff does a government impose upon you? So jury duty would be an example, right? You know, I don't want to say the military because the military was segregated, but let's just stick with jury duty for now. A social right was something that wasn't political in nature. For example, a school, or working, or a mode of transportation, a train car. And what it said was, for purposes of these political rights, which again were at this point basically jury duty and not much else, there cannot be segregation. But in all manners of social rights, basically everything else, the state had no interest in ensuring this sort of strict equality. That makes sense? It's not a very clear distinction. If you want to be precise, another one of the political rights is actually the right to bear arms, but states deprive that all the time. Because of the nature of discrimination and segregation, it was a fuzzy distinction at best. Okay. But in any event, the court went out of its way to read the 14th Amendment as narrowly as humanly possible. Now, I asked the question last week, why, right? Why did the court do what it did? And it offered two possible explanations, right? So on the one hand, I asked, well, what happens if the court said in 1896 that Louisiana was obligated to segregate their trains? Would the state have complied? Probably not. Would there have been bloody race riots and lynchings? Maybe. Does the Supreme Court want to be in the business of issuing rulings that people ignore? Look at Roger Taney. No. So perhaps one explanation is the court realized that they did not have the power as judges by themselves to rule in this manner and force people to promote this notion of equality. The other explanation I gave was a little bit more cynical. By the Supreme Court in Plessy saying that separate was okay as long as it was equal, they gave their blessing to segregation. They put their blessing on Jim Crow, if I may, the word imprimatur, they gave the imprimatur to Jim Crow. And they basically said, as long as you guys pretend to have equal accommodations, segregate away. And this is really the lesson we get leading into the cases today, Cumming, Giles, and Berea, right? In Plessy, they drew the line in the sand, so to speak. They said, all right, we're not going to police this, right? We're not going to step into it. My sense, in that case, only Justice Harlan dissented, right? But my sense is that over time, the justices came to regret that decision. Because as they saw the growth of Jim Crow, they were like, oh, what do we do? But they still were not able to reverse the Plessy precedent for the same reason. It will be ignored. And not just ignored, there have been years of reliance upon it. And the justices don't like to get rid of precedents that people rely on. In fact, the entire Jim Crow was built on this notion of separate but equal. Like you have an entire legal regime, which SCOTUS had blessed. They could not strike that away. And indeed in Brown, and this is probably the most disappointing case to read, did Brown overturn Plessy? Nope. Did it say desegregate immediately? Nope. It said with all deliberate speed. So the first three cases, Giles, Berea, Cumming, Giles, and Berea, represent, I think, what the court is trying to come to grips with. Okay, we screwed up. Let's try not to make this worse. Let's try not to extend Plessy. You'll notice in those 3 cases, Plessy wasn't even mentioned. The judges went out of their way, like bending over backwards, to avoid the constitutional issue, resolving on corporate law, right? Regarding on equity, all these other bizarre rationalizations. They did not want to add more blessing to the Plessy doctrine. And I think, and who knows, what do I know, right? But I think that's what they were trying to do, avoid the issue. So when you read these 3 cases, Giles, Berea, and Cumming, you have to read them in the context that Plessy is still controlling law, and that since there was not enough backbone, if you will, to come out and say that Plessy was horribly wrongly decided, they had to do these other contortions to continue the charade of not causing race riots and civil disobedience. I mean, even when Brown was decided in 53, 54, there were billboards throughout the South that said impeach Earl Warren. You've probably seen these in history books, right? Impeach Chief Justice Earl Warren, to impeach him, right? Had they done this 50 years earlier in 1901 or whatever, right? There would have been a lynch mob at the Supreme Court. I mean, at this time, Woodrow Wilson was hosting, was named Griffith, the movie The Birth of a Nation, a Ku Klux Klan movie, right? He was hosting a filming of this movie at the White House. Wilson segregated the military in the 19-teens during World War I. This was not a time the court could have ruled this way. Does that make it right or wrong? Well, we can discuss this later. So let's go through these facts. Where to finish off? Thank you, Roy. Appreciate the honesty. Roy, what were the facts in Cumming? And by the way, this is Richmond, Georgia, not Richmond, Virginia. I thought it was Richmond, Virginia when I first read this. So what are the facts in Cumming, sir?
We had a school in Richmond County, Georgia, who had for a while maintained a black high school for the male students.
Yes, sir.
And decided after some time to discontinue servicing those students in order to provide for a high school for the white female students. And they were supplying it with, they were all paying equal taxes on it though. So there was also not a school for the white high school guide for the white high school boys either. So this was specifically about the high school for the white girls, high school girls. And I think the state had legislation that provided that all the students just had to be educated through, I guess, what it counts to elementary.
Primary school.
Primary.
Thank you. Spoken like a true principal, right?
Yeah.
So were you principal at school you had again?
Buena.
Okay, very good. Thank you. So again, Plessy was good law. Plessy was 1896. This is 1899. So not even 3 years after Plessy, this case comes up. Right, Roy? Could the lawyers for Mr. Cumming have walked into court and said, "Your Honor, Plessy's illegitimate. We're not going to follow it"?
No, sir.
What would have happened if they said that?
They would have referred right back to Plessy and said, there's nothing wrong.
Yeah, and I'm going to just briefly detour in this because we'll come back to this when we do gay marriage in a couple of weeks. Let's see. I was going this way. I can't remember where I was going. Here, Jared. Do you think it's unethical for a lawyer to argue that Supreme Court cases are illegitimate and should not be followed?
I don't think it's unethical if you're trying to be, I guess, correct law.
Oh, yes, you said. What's correct law?
Well, in this case, it would be you would keep from the Plessy doctrine, trying to get out of it.
Yeah, but who's to say what's correct?
What is correct?
Yeah, who's to say what's correct?
Well, Supreme Court gives a ruling, but
They ruled Plessy separate but equal. They ruled.
but I guess it's it's still up to anybody to determine what is correct or not.
Ooh. So if you see what I'm getting at, you should, right? After Plessy, civil rights lawyers were very clear. They were open in saying that Plessy is illegitimate, that this is a wrong decision. And they realized that we can't go to the Supreme Court tomorrow and ask them to overturn Plessy. So groups like the NAACP, with people like Thurgood Marshall, who was a justice later in life, who was their director, said, okay, we got to take the long haul. Make little victories here and there, right? Go after housing, go after schools, go after taxes, go after education. They couldn't go to Brown right away. They really needed a long path, 50 years to get there. But on this notion of whether the Supreme Court is always right, they do not have a monopoly on interpreting the Constitution. And indeed, for much of the 20th century, while Plessy remained good law, lots of lawyers said that that's a legitimate decision. You recall from last class where Abraham Lincoln said Dred Scott, not a legitimate decision. I will ignore it. I think you asked me, did they suddenly just open up slavery in the territories? No, they said, screw it, I'm not following it. So it's a very interesting question of whether lawyers have any sort of ethical obligation to actually comport and comply with Supreme Court precedent, or they could openly call for it to be disregarded, as Abraham Lincoln did with Dred Scott. And we'll come back to this in the gay marriage decision in a few weeks, but recently a number of law professors released this statement basically saying that a Bergefell, the gay marriage decision, was illegitimate. And they analogize it to Dred Scott. And they say that this decision is entitled to no respect and that we should begin a campaign, however long it takes, to nullify it. And a lot of law professors are getting angry, saying, well, this is unethical. That we need to respect the Supreme Court, and we need to listen to what they do, and we can't question the legitimacy of their judgment. And it's been giving a lot of thought recently because, frankly, in our history, that hasn't been the case, right? You've had people take it upon themselves to say Dred Scott was wrong, Plessy was wrong, and they say this is not legitimate. We should not be following this. And then someone say, well, but Plessy reached the right result, the correct result, right? We have to overturn Plessy, so we have desegregation, or we have to get rid of Dred Scott, so so the people are there's no second-class citizenship. Of course, we can say one way or the other. Gay marriage is good. The arc of the universe is long that bends toward justice, as MLK said. Well, these professors don't agree. They think that the gay marriage ruling is bad. And once we start going to values judgment, whether right or wrong or you were correct, it isn't so easy. Right? Once we move beyond the Supreme Court having the final say on certain issues, it comes down to independent judgments. And I don't pretend to have an answer. In fact, this is an issue I've been grappling with extensively over the last couple months as a Bergefell, and maybe I'll work up work up an idea when I teach a case in a few weeks. That one I'm planning way out. I got to think that one through very carefully. I take stuff seriously, but we have this long history in this country of treating decisions as illegitimate that people think are wrong. And if we allow people to take it upon themselves to call decisions illegitimate, well, what happens if lots of people start agreeing with them? And indeed, I think that's what happened to Plessy ultimately. By the time we get to Brown in 1953 or whatever it was, the sentiment of people was at the point where the court recognized, okay, if we rule this way in a deliberate speed manner, we won't have a civil war. We won't have race riots, although those things indeed did happen. Rant over. Any questions on that before I get back? I'd meant to say that last class. I didn't get a chance, so this was my opportunity. So I planned these things. So what happened here? As Roy said minutes ago, the city effectively closed down a school for black boys and opened up a school for white girls. So generally, Nikolai, is there any way, Nikolai, for citizens, right, to complain to the government about how tax dollars are being spent? What's the usual method that citizens complain about how a tax is being spent? Yeah, exactly, the political process, right? By the way, Denmark got a nice shout out last night.
Yeah, I heard about that.
Well, yeah, I don't feel the burn. So the usual process, right? The usual process by which people challenge how tax money is being spent is political, right? you vote. Now, I'm going to pause here briefly to note that, by all accounts, the black people in this town could not vote. I'll just put that aside. But usually, you challenge taxpayer expenditures based on the political process. But Nikolai, what was the method that that they used in this case to challenge the decision to spend money on the white girls' school instead of the school for the black children? Yeah. Okay. So here's the issue, right? And again, I'm not saying this case was rightly decided, but the method they used to challenge this was atypical for the courts, right? Because they could not challenge in the ballot box, they couldn't vote because of the literacy test and the poll taxes, right? They went on to the court system, and they effectively said, okay, we're not going to challenge this on separate but equal grounds. They couldn't. Plus, it was good law. So they effectively said, what? It's unfair that they're taking money away from the black school and putting it towards a white school. Okay, that was the only argument they could make. So Toshiba, assuming that the court agreed with them that was unfair, what was the only remedy the court could provide here in this case?
That they talk about in the notes, the 3 different types of remedies, or
Well, in this case particular, right? Assuming that Mr. Cumming was correct, what's the only thing the court could order the Richmond Education Board to do?
programs,
Which school?
the girls' school.
Yes, the only thing that could be done was an order from the court to shut down the girls' white school, the white girls' school. Toshiba, could they force the city to now open up a black school? Exactly, the answer is no. And this is what I think Justice Harlan was trying to do, right? He was trying to thread the needle very thin. He basically said like this: even if we were to agree with them that this was an unconstitutional act, all this court could do would be say, okay, don't spend this tax money on a white girl school. At the time, the federal courts simply lacked the jurisdiction to compel a school board to open up a school for black children. Okay? Jennifer, what's the real remedy you think that Mr. Cumming wanted? You think he wanted a black school there, a white school there? What do you think the real remedy he wanted was? What do you think the real remedy he wanted they couldn't ask for? Do you think he wanted a black school and a white school? What do you think he wanted? Yeah, right? So, I mean, if you actually asked him, right, over dinner where he wasn't in front of a courthouse, what do you want? He would say, I want the school to be integrated. But could he ask for that? Why? Bingo. Plessy was still good law. So the lawsuit was brought was saying, okay, how can we get something better for the black children without overturning Plessy? All right, let's try and get a principle that if you're spending tax money for a white school, you spend tax money for a black school. Right? That was the effective nature of the claim. But Justice Harlan said, and this part was probably correct as a matter of equity, we're not in a position to order schools to spend money on anything. We can tell them, fine, don't spend money in this girls' school, then everyone's worse off. There are no schools. Is this correct? I mean, it's fishy. But Harlan was basically trying to not invoke Plessy. The way he ruled the decision wasn't invoking Plessy. He wasn't saying, well, you know what? Having separate school districts is just fine, right? That would have been worse. Because Plessy discussed education, and I'm sorry, transportation, not education. And one thing you want to know about Justice Harlan is that, again, he was a teacher, right? He was a law professor, and he actually taught Sunday school at his church every single Sunday. He would teach constitutional law classes Saturday night, and then Sunday morning he taught Sunday school. He was an educator. He loved education. Brilliant, brilliant guy. So he understood the significance of education in the big scheme. He did not want to have a ruling basically sanctioning this sort of discrimination. Okay. So ultimately the court held, we don't have the authority to integrate the schools. If we shut down the white girls' school, then the white girls are worse off. We can't do anything. Dismissed. All right. Any questions about Cumming? Yes, Jeannie.
It's a two-part question.
Okay.
The first part is, did the court determine who would write the opinions back in 1899 in the same manner that we do today? And in that comparison, in that role, do you think it was any bearing on Justice Harlan having written the dissent and Plessy being the one who wrote that?
So the tradition then, as it is now, is that the most senior judge in the majority opinion assigns the case. So in this case, the Chief Justice would have been the most senior judge in the case, and he would have assigned the case to Harlan. Yeah, I think it was a smart move to give to Harlan because he was able to write a decision without extending Plessy, and that's significant, right? As trivial as this decision is, it doesn't make things worse, right? Everyone get that? This doesn't make stuff worse. And he even leaves open the possibility that maybe if another case comes where there's evidence of using racial animus, maybe that could be a case where they strike. And he hints at it, right? He kind of like, he suggests it, but no, that's not the facts here, right? I mean, come on, they shut down the black school, the white school. I can't think of a more obvious example, right? But you know, they couldn't get there.
I guess wondering about they said it was like the greater good, I guess, the greater interest for shutting down the 60 kids of a black high school versus like 300 of a primary school.
Yeah.
What if it had been like 300 in the high school? Would that decision have been?
Or what happens if they would just shut down the black school period and not done anything else? Right, they just shut down the black school, use the money to pave roads.
And what was the justification then?
So I think they took this case because they could resolve on very narrow grounds. The Supreme Court's not obligated to take every case.
How much weight does he give to the state statute there? I mean, that primary schooling has to be given versus.
Yeah, so this is an important point that's hard for you to appreciate today, right? Until the 20th century, states didn't really provide higher education, right? There were not really high schools in states. You stopped at primary school. You had to be a farmer, whatever, agriculture. So if the Constitution doesn't even require spending money on high schools, then how can the court step in and say that they have to, right? If not even the Georgia Constitution makes the states pay for high school, how in the world could the Supreme Court order go open a high school for black kids? It was beyond the judicial role. Now, the 20th century, right? The Warren Court did this stuff all the time. They said, yeah, open up this school, segregate that school, desegregate there, make this stuff up. I mean, if you guys took property, take property to it or no? You'll do some crazy property cases in property too, where they basically tell cities to build affordable housing and stuff, right? Courts get more ambitious, but back then this wasn't even an option. Yes, ma'am.
If they can order them to open up a school for black kids, why is it not the separate way for white kids? They make them do one so they have to for white kids. Because right there, it's not equal.
Right. So I think Caleb's point is a response. There's no obligation to even make a school in the first place.
But that's a white school would be what?
There was no high school for white boys. And the court said this can't be based on race because the white boys didn't have a high school either. Right? It's not a perfect decision, right? But I think Harlan's trying to thread as narrowly as he can. He didn't make stuff worse, which I think is his effective goal. So let's go into the second case, Giles v. Harris. And this case is a little confusing, so I'll walk through it slowly. It was actually authored by Justice Holmes. I'm not a fan of his, but we'll explain later why. Who was I up to? Oh, yeah, you. Go for it. What happened in Giles, Caleb?
Okay, so. Should I get this right?
Yeah,
Giles.
yeah, go for it.
You have a situation in Montgomery, Alabama, fairly important place.
That's where Martin Luther King spent his night in the jail cell. I was actually at the. If you ever go to Montgomery, they have a very nice civil rights museum. It's actually really nice. I really enjoyed my time there. So if you ever visit Montgomery, check it out. Go for it.
The plaintiff in the case actually.
Oh, also look, yeah, that was Birmingham. Crap, wrong city. I was so close. It was Birmingham. So but close.
Montgomery and Selma.
Yeah. I was. Yeah, exactly right. I was so close. I gave it talking Birmingham, but Cornfield, sorry.
So in this case, the plaintiff alleges that he had registered according to the
Registered
state
to vote.
statute, registered to vote
Right.
according to the state statute, which required before August 1st, 1902, but he still refused the services and the privileges of voting that every other white person had been given. He was also not the only person in this instance. There were several other people that had met those requirements and yet were still disenfranchised.
Very good. Okay, so here we have is a combination of a grandfather clause and a literacy test. Right? These often work in tandem. So what did the grandfather clause say? If you were a registered voter before, was it 1902? Whenever I ignore a call on my phone, it then rings my computer, which I was speaking about. So if you were registered to vote before 1902, which basically means you were white, you are good, you're set to vote, okay? What happens if you were not registered to vote? You have to take this literacy test, and you have to be able to read and write any article of the Constitution in English, and that means write from memory, folks. That's not like copy. That means like recite from memory, the entire 14th Amendment, which I guess would be pretty poetic, but difficult nonetheless. No doubt these tests were imposed in a discriminatory fashion. If you were white, you'd have to do nothing. If you were black, you'd have to write this impossible test. If you actually Google some of these literacy tests, they were hard. I know this stuff, and I couldn't pass these exams. Like, you have to recite entire passages and these obscure questions about this clause of the Constitution. These were meant to fail. There's no doubt about these at all. Okay, so what makes this case difficult? Kevin, could Mr. Giles, or is it? I can't remember which was which. Could Giles sue and argue that this registration scheme violated the Constitution? That this was unconstitutional? Could have. What amendment would he rely on? John, one more. What's 15th Amendment? Think about it. This is open book.
Can't limit the right to vote based on race.
Yeah, the right to vote should not be denied or abridged on the basis of color or race or previous condition of servitude. This is actually all the above because it basically excludes former slaves and people of color. So, Kevin, why didn't Mr. Giles go in and sue under the 14th Amendment or the 15th Amendment or any? Why do you think he didn't do that? Yeah. So we don't have Plessy here, right? There's not an equivalent for Plessy. There wasn't really a voting rights case brought. But these people realize they start bringing constitutional claims to challenge registration, it would be very bad. And the court would not be inclined to grant it. So instead of arguing outright that the registration system itself violates the 14th and 15th Amendment, Brian, what did Mr. Giles and his fellow class try to do?
Get like an injunction that would say that he could vote.
Yes. He wanted a bill of equity, effectively an injunction. You're exactly right. That would have compelled the city to register him to vote. But the problem is this, and Justice Holmes, in a weird way, addresses it. Neri, what's the problem with registering you under this overtly racially discriminatory regime?
He says that there are two issues. One, if they were to register him, then they would be acknowledging that this law is valid.
Exactly.
And they're not willing to do that. And additionally, for them to just add it and validate the law, they'd be shutting their eyes to any future blocks on board.
Yeah, that's exactly right. So Holmes is like this. He has 2 points. So first he says, what would give this court the power to make them register Mr. Giles? That this action is unconstitutional, that this policy is unconstitutional. All right? But if it's unconstitutional, then why are we making them comply with it? Right? If it's unconstitutional, why would we comply with it? And then second, this would make us basically turn a blind eye and say, okay, deal with this unconstitutional policy, but we won't say why, right? Effectively, we say, because it's unconstitutional, register them under your racist system. Everyone get that, right? Holmes is basically saying, without saying it, it's like, you can imagine he's screaming into his hand, this is unconstitutional. But if we say it's unconstitutional, we'll be in trouble. We can't do that. So let's bend over backwards and say, well, we're not going to make you comply with an unconstitutional system. So instead of, perhaps making stuff worse by saying, oh yeah, this registration system is fine, right? What the lower court said, yeah, this is perfectly fine. They're saying, well, we can't do anything here, so we'll just, we're not going to dismiss, right? The most obvious answer would be, this system is unconstitutional, make a new one, and then you can register under that system, right? But again, was this what year was this? 1903. The court couldn't do it. The court, and Justice Holmes in particular, realized there's no way in hell that they could make this ruling the way they did. Yes, ma'am.
Why wouldn't they argue it under the separate but equal premises? That the law was.
Why wouldn't the court?
No, well, why wouldn't,
Giles?
wouldn't it? Yeah, that there's this rule, that here's how you become, able to register to vote, and it's not being applied equally.
So yeah, so Lindsay, your point's fair, right? So the dirty secret of separate but equal is that it never actually mattered. Even in Pleasant, the train cars weren't equal, right? Even in the case we'll do later, the Brown case, the black school wasn't equal to the white school, and courts overlooked that. So he probably did try to make that argument in the lower court, and they said, no, it's equal enough. But you're right, he could have argued, but the rub of separate but equal is it was never actually enforced. There was never actually a judicial command to make the accommodations equal. So unfortunately, that was no lose.
On both the cases that we went over today, it seems that the court, like you said, is going through a narrow path. And whether it's in the first one because of taxation from a state citizens for a state school, or in this where in the last paragraph of the opinion it says that the court can't send people to adjourn over the voting ballots over that.
Yeah, isn't that something, right? Yeah.
They seem to be looking for legislature to step
Yeah.
in with Thomas Clause for taxes.
Yeah. I mean, yeah, exactly right. So Justice Holmes in the last paragraph, I'm glad you point that out, it says like this: we can't as judges sit and require someone to look over the ballot box to make sure it's being implemented, right? Even if the Supreme Court ordered them to have a fair voting system, do you think they would have complied with it? Of course not. So again, they don't want to issue a ruling that's going to be ignored. So what ultimately happened was the Voting Rights Act was enacted in, was it 1965 or 4, whatever it was, right? And that basically said the Justice Department can supervise elections and file lawsuits in the event that discrimination is going on at the ballot box, right? What Holmes was suggesting should happen took another 60 years to do. Oh, Kelvin, sorry.
I'm sorry, I can't remember where I read this from Plessy or something today, but I mean, the court actually says outright in one of their opinions that it really doesn't matter if it's equal so long as it serves the same basic function.
That was pretty much Plessy.
Okay, that was Plessy. Okay.
Yeah.
Yeah, so I mean, in that instance, I mean, the court doesn't even really make much of a deal about it being equal, just so long as it generally the same thing is happening. As long as you move from point A to point B.
So I think you have to distinguish the state courts and the Supreme Court, right? These cases all came through the state court system, and frankly, these judges were not interested in ruling in favor, right? The Supreme Court then ducks all the issues. So the state courts will say, oh yeah, sure, they're equal. The language like they're substantially equal accommodation. They'll not be perfectly equal, which has some wiggle room. What did Justice Harlan say, Marcella? In his brief dissent, you can tell he's pissed off here, right? It's like a brief one, but oh, they omitted it. Oh, I'm sorry. I have this problem. I always read the real cases, not the edited versions. So I did this again in property today too, because they had Shelley v. Kramer, which you haven't said yet, but I always read the full cases. So Justice Harlan basically said, the court has jurisdiction to hear this case. He basically said, it was like one paragraph. This entire BS about the equity, cut the crap, right? Let's just go to this. And Harlan says the plaintiff is entitled to relief to register to vote, period. It's really short. It's like a paragraph long, but he's basically like angry, saying like, why are we doing this stupid equity thing? Let the guy vote. Maybe he can vote to office his own people who will make the system more fair. You know, do something. Don't just sit here and like put your head in the sand. Which is why those of you who perhaps are miffed at Justice Harlan, he does redeem himself, I think, quite a bit. So, any questions on the Giles case? All right, Marcelo. So here up yourself. Let's talk about Berea College versus Kentucky, and I'll give some background. Berea College, which is somewhat near Lexington, was founded in 1850 as one of the first colleges in the country that was integrated. I think the first one was in Ohio, Oberlin. I think Oberlin was the first integrated college in the country, if I'm remembering correctly. Berea was founded as a Christian university that they said, you know what, if you want to come here, you can work. And it's still in session. And the purpose of the school is to give people training skills, like to be a craftsman or be like a mechanic or to be a carpenter. It wasn't like an educational school you think of, but they were trying to train people to have jobs. And they serve a very, very important function, even today in Kentucky. I clerked there for years, so I know some stuff about it, but it was a very significant school. So tell me about the law that was passed, Marcella, that Kentucky passed.
They had a law that made it unlawful to receive for any kind of schools or company to operate or to accept those things.
Okay, good. So the state passes a statute, right? And the purpose of the statute, Marcella, is pretty clear. What's the purpose of the statute? Just overarching. And not just not integrated. What for private school? Again, this is a private school, not a public school. The public schools were absolutely segregated. What does it say to the private schools? Yeah. What's it trying to do to the private school? What the private school wants to integrate? Can they? It makes it a crime. A crime punishable like fine. And then was it $500? That's a lot of money back then, right? For a small Christian college, right? The purpose of this law is to criminalize schools that want to integrate. It wasn't bad enough that the law required segregation in public accommodations. They went out of the way to criminalize private institutions that sought to have integrated accommodations, right? And the law accomplished this in a few different manners, right? So first, Clint, with respect to corporate charters, the corporate charters of a school, what could these corporations not do?
Have blacks and whites learning at the same time.
Yeah, it made it a crime. And it basically said any university which is a corporation, South Texas, it's a corporation, right? Any university that's a corporation cannot have blacks and whites studying together at the same time. I think they even said they'd be like 25 miles apart or something, right? You can have separate institutions just like in different cities. And by the way, there were no cars back then. 25 miles in rural Kentucky was a schlep, okay? That was very far. But this law didn't just touch the corporations themselves, right? Iris, who else was, and this is actually Justice Harlan's dissent, he goes to the full statute, but who else was subject to this law, Iris? Yeah, the teachers themselves. And what happened to the teachers? Yeah. So look, this wasn't just going after the corporations. This was going after the teachers themselves. So even if you had a teacher in a one-room shack, right, in the middle of nowhere, Kentucky, who wanted to have a black and white child study with her, she could be fined by the state. You see what Jim Crow tried to do? It tried to effectively, at every juncture, even those of goodwill who would seek to have integrated accommodations, criminalize their behavior. Okay? So again, the purpose of this law was to make it absolutely illegal to educate black children alongside white children. I mean, there's no doubt in any reasonable mind what this law was attempting to do. So, Bridget, how does the court go about resolving this issue?
They say that the state has the power of its own corporate. They say that they have the right to alter, amend, repeal, deny due process of law, or otherwise stop from violating the Constitution.
Good. So the facts of the case were, who was the Bridget, who was the defendant in this case? Was it a teacher?
The state.
No, the state was the prosecutor. Who was the defendant? What was the name of the case?
The college.
The college, right? The defendant in this criminal case was the college, not an individual person, right? Not a teacher, the corporation. By the way, when those people say corporations have no rights, this is what happens when corporations have no rights, by the way. You say, oh, you can teach privately, just you can't do it in the corporate form. Well, most people can't run colleges without a corporation behind it. So another absurdity. But even back then, right, they said, we will prosecute the college. The court and the majority ignores the fact that a teacher, a private teacher, could be punished as well. And like Bridget said, they seem to suggest that if they went after a private teacher, right, that will be problematic. But because here they're only prosecuting a corporation, that's okay. This is a silly distinction because they could have prosecuted a teacher just the same, right? So Andrea, why could the university be treated differently than a private teacher? What about the university allowed the state to impose these conditions?
Private.
What was the significance of it being a corporation? What was that significance? And I realize you haven't taken corporation law yet, but you could take a stab at it. What is a corporation? Okay. And who allows a corporation to exist? Do you know a form of corporation? You ever done anything like this before? Michelle, you have any experience with this?
I do not.
Anyone have a form of corporation?
State allows you.
Yes, sir. Exactly right. Under state law, if you want to form a corporation, you have to play by the state's rules. Have this many officers, have a treasurer, have a president. You have to file these reports every year, right? There are very strict rules for having a corporation in the context of campaign finance, right? If I want to give a donation for my own name, right, I can just write a check to a candidate. If I want a corporation to, I have to establish a PAC or a super PAC and follow a host of different rules in order to exercise my constitutional rights through the corporation. Okay? Generally speaking, people like using corporations because you have more persons than one, collect funds and collect ideas and collect momentum. But here effectively the court says like this: because Kentucky has absolute control over whether it can establish a corporation in the first place, they can set the conditions by which your corporation exists. Let me say that again. Because Kentucky can control whether a corporation exists, they can control the circumstances under which it exists. And here the court says, there's no big deal if those conditions are saying you can't have an integrated school. What's the big deal, right? You know, they say you have to have a president, you have to have a treasurer, you have to file an annual report. And oh, by the way, blacks and whites can't read together. Michelle, what's the court doing here, consistent with the last two cases we read? What are they doing?
Again, that they didn't want to get into where saying whether this state rule or law regarding her was unconstitutional or unconstitutional.
Yeah,
They steered away.
exactly. This is the same deal, and I like the way your textbook puts these three cases back to back. It's a very good sequence, right? Not all books do this, but I like how this book does it. They were trying to avoid a ruling under Plessy because, well, Lindsay, let me ask you this question. Would having a school 25 miles away be actually an equal accommodation? Of course not, right? Right? Of course not. The judges aren't idiots. They realized they couldn't have schools 25 miles away being an equal accommodation. Teachers can't travel that far. There are no cars back then, right? So instead of ruling that this was, in fact, equal accommodations, they go through this convoluted corporate law analysis, which allows them to rule for the state, but not make it worse, not make any new law that makes Plessy more firmly entrenched, right? It doesn't make Plessy deeper embedded in our society. It just kind of leaves it where it is. Okay, everyone get the majority opinion. We'll go to Harlan in a minute. Any questions in the majority? Yes, sir.
I mean, how do they get away? I mean, I know that they call it severable, so they can look at each section of a law individually. But I mean, how do they get away with that? I mean, because it seems shady. Like
Disingenuous, right?
Yeah, very much so.
So, okay, so Caleb's point is like this, right? The majority only quotes the first part of the law that punishing the corporation, right? And Harlan quotes the entire things like, you guys, this goes after teachers and everyone else. What the majority says is like this: the only case we have is a prosecution against a corporation. We don't have a prosecution against a teacher. If that case were to come to us, we look at it differently, right? So, I mean, what they're doing is not indefensible, right? It's shady, to use your word, perhaps, right? But they're saying the only thing we have here is a conviction for a corporation. If you bring us another conviction for a private teacher, maybe we'll rule differently. Now, will that ever happen? Does Kentucky need to punish a teacher? Would any individual teacher, a poor teacher, risk a $500 fine so she can teach these kids? Of course not. Only the corporation, which has funders and donors and alumni, can back up this sort of challenge. Kentucky Berea College was operating in violation of the law. They knew this law was illegitimate. They were doing it anyway. They went and they got fined because they want to teach these kids together. No teacher in a one school shack would be that dumb, right? I don't care how high her principals are. She's not going to jail as a debtor, not paying out that $500 fine. So yeah, that part I think was disingenuous. I think that's a fair characterization.
So could you read this similar to then the majority holding in
Giles?
Cumming?
Yeah, exactly.
Where he says, you know, if some other proceeding had been brought, should you read it that way, or should this be read as it seems, which is they're really bending over backwards?
Bending over backwards.
Okay.
Yeah, and I mean, I like how the book sequences these three cases one after another because they really show, you know, with respect to equity law, with respect to, you know, tax law, with respect to corporate law, how can we not resolve this in constitutional grounds? Let's go to Harlan's dissent. Tam, this one I think is in the book, right? Yeah. Tam, what does Justice Harlan write?
He said that the state doesn't have the power to control a corporation.
Well, they have no power to control the corporation? What does he say?
Well, he doesn't have the power. The state doesn't have the power to punish the corporation.
Okay, good. Tam, let me ask you this one last question. Does Harlan come out and say that Plessy's wrong?
No.
Okay, he doesn't. Okay. What he says is like this. We're not stupid here, right? The purpose of this law manifestly was to prevent private institutions from discriminating against Black and white children studying together. He says this entire, if I may, BS about corporate law was mentioned in one sentence in the lower court opinion, right? The lower court mentioned briefly in like a sentence that, oh yeah, by the way, as a corporation, the state can do whatever they want, right? That was not the basis on which this case is argued below. The Supreme Court resolved this on a totally different ground. But again, he can't come out and say that under the Equal Protection Clause, this is unconstitutional because, again, Plessy, right? So, Daryl, what clause does he rely on to reach this result? What clause of the Constitution? He relies, he mentions it. You know what? Ah, you break my heart, Daryl. Yeah.
It goes to the actual liberty term in the 14th.
The Due Process Clause. No state shall deprive a person of life liberty, or process without life, liberty, or property without due process of law. Tim, what is the liberty interest here, right? What is the liberty interest that the state is violating? What is this liberty interest here?
That a black and white kid could sit together and be instructed by a teacher.
Learning. Ain't that something, right? The Constitution guarantees you a liberty interest in education. Whoa. Right? And this isn't just education from a one-room schoolhouse, right? He's saying that the corporation has a right to teach. So all this Citizens United stuff, you can just whatever, right? This is not new. Harlan's saying that the corporation, Berea College, has a constitutional liberty interest in teaching, right? The students weren't being punished here, right? This isn't a right to learn. The students were not being fined. It was the teachers that they have a right to study. We'll do a case in about 3 or 4 weeks called Pierce v. Society of Sisters. Pierce versus Society of Sisters. The facts were like this. I think it was the state of Oregon passed a law banning private schools. Okay, the manifest purpose of this law was to punish Catholics. It was an anti-Catholic Catholic law because only private schools were Catholic schools. So basically they say all private schools are banned. And the Society of Sisters, a corporation, brought a suit saying this violates our liberty interest in teaching students. And the Supreme Court in the case said, yes, you're right, that you have a liberty interest in teaching. Okay? This is part of that same evil doctrine of substantive due process that we will debate over for some time, right? Right? Michael, where does Harlan get from the 14th Amendment a liberty interest in teaching? Where does he get this from?
I think what he said was an invasion of the rights of liberty and property guaranteed by the 14th Amendment.
Yeah, but teaching. How is teaching a liberty interest protected?
The profession you choose or something along that nature.
Oh, so do you have the right to as a profession to work as a teacher? Is that it?
Possibly.
I like that. So effectively what Harlan's saying is that this liberty clause, if you will, the 14th Amendment, guarantees rights that are unenumerated. The phrase education is nowhere in the Constitution. The phrase choosing an occupation of your choice is nowhere in the Constitution. But Harlan derives this from his reading of the history of the 14th Amendment. Indeed, you'll recall that we cite Slaughterhouse, or the Privileges or Immunities Clause, right? One of the rights often discussed at that time was the right to earn a living. So when the state of Louisiana shuts down all the slaughterhouses and says you can only use this one, it puts you out of business. It takes away your living. And Justice Field's dissent in Slaughterhouse said that you have the right to pursue your vocation. Harlan is channeling that. Even though Privileges or Immunities was dead, he's bringing into the Due Process Clause that same notion of substantive liberties. And this is during the era where the book labels pejoratively the Lochner era, but this is during an era where the court recognized various liberty interests. Because Plessy was good law, they could not go through equal protection. They couldn't. Privileges or Immunities was dead, so the Due Process Clause began doing a lot of the heavy lifting to guarantee substantive equality under the Constitution. Yes, ma'am.
This was the start of the era?
We'll do the Lochner case in a couple weeks, but there's no start or finish date. The book calls it a discredited line, all this other stuff. The authors and I have some disagreements on that, but they're good guys. It was really from the early 1900s to like the 1920s or 30s, depending how you count, right? Let me tell you about another case that's not in your book. Oh, it's mentioned briefly. Buchanan versus Worley. I think it's mentioned in a note somewhere. So the facts of the case were like this. In Louisville, Kentucky, I lived there previously, the city passed a law. And it said, okay, this is going to be the black neighborhood. This is going to be the white neighborhood, right? If you're black, you can't buy a house in the white neighborhood. And if you're white, you can't buy a house in the black neighborhood. Of course, the white people aren't going into the black neighborhood. This is means of segregation. But they say, look, Plessy, you have one neighborhood here, it's separate but equal. It's awesome, right? Okay. A lawsuit was brought. I think it was 1916 or 17, I can't remember the year. The lawsuit was brought. Could they argue that this was unconstitutional under equal protection? No. Plessy was controlling law. Had they argued that separate but equal is wrong, they would have lost. So what did they argue? That I have a liberty interest in the acquisition of property, right? You recall in privileges or immunities, you have the right to sell and acquire property. This is one of the freedoms protected by the Constitution. And what did the court hold? Yes, indeed, that the liberty of contract or the freedom of contract allows you to buy and sell property to whomever you want. And the state does not have an interest in stopping you from selling property to whomever you want. So in this case, as in Justice Harlan's Berea dissent, the due process clause, the liberty clause, was able to provide substantive protections against segregation. So when we say Lochner later, you'll see that there's a not all bad, as people often say, the discredited lie. Perhaps it wasn't enough good, but it wasn't all bad. So what do we have? We have Justice Harlan saying that because you have a liberty interest to pursue your vocation and become a teacher and teach, the state cannot deprive you of that liberty interest without any due process. Yes, sir.
I thought it was pretty good too, how he tied in more of the religious aspect.
Yeah, let's talk about that. That was my next point. Again, he was a Sunday school teacher. He knows what he's talking about, right? He knows the scripture.
Seems like it pulls a little more at your heartstrings.
Yeah.
Public's heartstrings to hear how black and white individual can't sit together in church versus can't sit together in a class.
Yeah, I mean, if you take the ruling seriously, right? You don't just learn in a school. You can learn in a church house. And if you go there on Sunday to do Bible study, right? And the church says, oh, the city says, wait a minute, that church is a corporation. Churches are corporations too. They are, trust me. That church is a corporation, and we will revoke your corporate charter if you allow a black and white person to sit there and learn the Bible together. Under the majority's opinion, corporation. Does it matter that it's religious? Well, at the time, the free exercise clause didn't even apply to the states yet, so there'd be nothing wrong with that. So Harlan definitely works on a very religiosity angle as well. At the end, Harlan makes clear, I'm only talking about private schools. He stresses that very strongly. He says, I am not talking about integrating public schools. That is a whole can of worms. They'll be resolved 40 years after I die, right? I am not going there. All right, so what was the holding, right? What was the holding? Well, the holding was basically under corporate law, states, corporations can be punished for not following the law. Does the 14th Amendment matter? No. But again, it didn't make stuff worse. It didn't reaffirm Plessy and say that, yes, we will allow, consistent with the 14th Amendment, separate schools for blacks and whites in college. It did not say that. So that was perhaps a saving grace.
That little throwdown line about the corporation thing they put in there, they have a leg to stand on, or how would they?
If you're saying they didn't do the corporate line,
If that didn't exist, if they,
they could have done it anyway.
So they would have had it.
The Supreme Court can affirm on any ground they want.
They just saw that and snagged and said, hey, now we pull this thread. And
Yeah, it's exactly what they did in Giles, what they did in Cumming. They pulled the thread through. All right, any other questions on Berea College? Very important case, and Harlan's dissent is very, hopefully he's salvaged in your eyes, I suppose. Maybe not, I don't know. I cut him some slack. It was actually funny. So, I mean, a couple of you asked about the Tawney bust yesterday. And I did some research and thinking about it last night. And, oh, let me find this quote. This is a great quote. So, in 1865, oh, come on. You really? You can do this now? My blog's done. Okay, I have the quote elsewhere. I want to read this. There it is. So in 1865, speaking of Justice Tawney and his bust and complicated figures, I have it here. The one member of Congress, Lyman Trumbull, who was a sponsor of the 14th Amendment, appropriated money to build a Tawney bust. And then Senator Charles Sumner of Massachusetts, if you saw the Lincoln movie, he was one of the fiercest abolitionists who championed abolition, said, quote, I object that now an emancipated country should make a bust to the author of the Dred Scott decision. Sumner replied, "Let me tell that senator that the name of Tawney is to be hooted down the page of history. Judgment is beginning now, and an emancipated country will fasten upon him the stigma which he deserves." So even in 1865, people were already trying to blot out the memory of Roger Tawney. As history often goes, when Chief Justice Chase died some years later, the next Chief Justice, they said, well, we need a bust of both of them. We can't have a bust of one of them. So they commissioned a bust for Tawney after things calmed down. And I actually blogged about this last night, and I got all these tweets from these people in Maryland who want to take down the Tawney bust. And one of them tweeted me was like, "Help us take down the Tawney bust." I'm like, "That's your thing. I'm not going there." Anyway, so back to Dred Scott, or sorry, Brown. So, before we get to Brown, anyone know about the case of Sweat v. Painter? Anyone know about this case? So, Janine, you know about Sweat v. Painter? Didn't you start at TSU? Did they tell you nothing about Sweat v. Painter? Oh God, really? Mark, want to tell us about that? Oh, Janine, you're gonna be so embarrassed. Like 5 seconds.
You're talking about the reason that.
Yeah, why is there a TSU law school? Do you know?
They're doing March.
Oh.
Yes. Okay, Mark, we defer to Janine.
Sorry.
Yes, Janine, go.
First day of orientation within the first 30 minutes.
Good. I'm glad.
Okay, sorry.
So, do you want to tell us?
Let's see. You're right, I am embarrassed. So, the state of Texas and lawsuit in regards to the University of Texas Law School allowing blacks to enter the law school.
Okay, so did UT Austin, which was like the at the time the only public law school. South Texas was integrated. We were good back then, right? We're 90 years old. We've been around for a while, right? But the only public law school in Texas at the time was UT Austin. And did they allow black students?
No, they did not.
Okay, so what did Texas do to comply with prevailing constitutional law?
They created TSU and the Thurgood Marshall Law School.
Exactly. So rather than desegregate, there it is. Rather than desegregate, what do you call it? Oh, there it is. Yeah.
UT Law.
Yeah. Rather than desegregate UT Law, right? They simply created a new one. They said, well, hey, Supreme Court, look, it's a separate school. It's equal. TSU and UT are exactly the same. Everything's kosher, right? Well, in a case called Sweat v. Painter, I think it was 1948. Janine, that sound about right?
Yeah.
Sweat v. Painter, the Supreme Court basically said that, these accommodations weren't in fact equal. And with respect to graduate schools, right, and the law in particular, you could not have these sort of unequal accommodations, right? So in Sweat v. Painter, they didn't overturn Plessy, but they basically said these schools are not equal. And with all respect to TSU and UT, they're not the same, respectfully. There were differences. There was more funding, more professors, all this other stuff. But that did not eliminate, though, the issue of public schools and especially primary schools. Anyway, well, this is actually the bust of Chief Justice Tawney at the Supreme Court. It's got to be intimidating. He's between John Marshall and Salmon Chase. Salmon Chase was Lincoln's Secretary of the Treasury, great Chief Justice, and he's kind of chilling there in between. Okay. All right. Where was I up to? Okay, so before we get to Brown, Brown's actually fairly quick. Oh, one more note on the corporations, right? So there was a note in your case about a decision called Bob Jones University versus United States. Anybody know about Bob Jones? Anybody know about Bob Jones University? I'm sorry? What?
It's a Christian university.
Okay, so Bob Jones is a Christian university in South Carolina. Until as late as like 1980, they originally were segregated, and ultimately they desegregated. But as late as 1980, they did not allow interracial dating. Right? The IRS moved to revoke their tax-exempt status. As a university, they're tax-exempt, South Texas or TSU. And the university said that that violates their religious liberty. And the Supreme Court basically rejected that claim in a case called Bob Jones, because they said that, you know, as a corporation, you know, they've surrendered certain rights and they have to give up their this benefit, right? They don't have to allow interracial dating, but they don't have to get a tax-exempt status if they don't. So why is this case an issue? I keep talking about gay marriage. It's been a defining theme of the second half of this class. But during oral arguments in a Obergefell, Justice Alito asked the Solicitor General this question. He asked, all right, so under Bob Jones, the court held that you can take away a corporation's tax-exempt status if they are racially discriminatory. Okay. What happens if a religious university refuses to provide married housing to a same-sex couple? Right? Most universities, if you're married, they'll give you special housing for you and your spouse. What if a Christian university says, well, we will not give housing to a married same-sex couple? Can their tax-exempt status be taken away? They're a corporation, right? Religious perhaps, but they're still a corporation. What did the Solicitor General say? It's going to be an issue. Those are, I'm quoting exactly. This is what I have in memory. Yeah, that's going to be an issue. So I think what we'll see in the years to come with respect to the aftermath of Obergefell is questions over whether certain institutions, such as religious universities and churches, can maintain their tax-exempt status if they do not, in all respects, recognize same-sex marriages. I don't think the IRS will be the first to jump on this. You don't need the IRS to do it. For example, most churches are exempt from property tax, and that's decided by the city. If you have a church in New York City, you are saving millions of dollars a year in property tax. So what if the city of New York says, okay, wonderful. If you don't recognize gay marriages and you exclude gays from your parish, we'll take away your tax-exempt status for property tax. Shut down. Immediately, shut down. So I think this is going to be the next front. As the Solicitor General said, this is going to be an issue. And whether jurisdictions are willing to preserve this tax-exempt status. Indeed, I think a couple of days after Obergefell was decided, some guy in Time magazine wrote, yeah, we should get rid of tax-exempt status for these churches. They don't need it. Anyways, we will see that issue. Michelle?
Okay, well, we have a Proposition 1, I think it is.
Oh, you going there, aren't
Coming
you?
up on for the city.
You're going there, okay, yeah.
So, yeah, I mean, what's gonna happen now with all these nonprofits you get?
I actually did a podcast on this law. So you're informed Houstonian. So long history. So the Houston City Council last year enacted something called the Houston Equal Rights Ordinance, or HERO, if you will. It provides a series of protections against discrimination for LGBT status. One of the provisions that has garnered perhaps more attention than others says that in places of public accommodation, you cannot discriminate on the basis of gender identity. Okay, what does that mean? If a person identifies as male, you have to let him in the men's room. If a person identifies as female, you have to let her in the women's room, okay? Opponents of this law have seized this and they called it the bathroom bill. And if you listen to the radio and Lance Berkman, and every 5 seconds they're saying, don't let some creepy dude into the girls' bathroom, right? I'm not going to go into the merits there, but I will stress one aspect of the law is it doesn't apply to kindergartens and pre-K. Why did the framers of the law make this not apply to kindergartens and pre-K? Were they worried about transgender people who work at kindergartens? That's a very weird exception. In fact, they conceded this. People haven't actually noticed, but they effectively exempted this. So a kindergarten does not have to allow a transgender person to the bathroom of their choice. Think of the children, I suppose. Law. What happens if you are not a church, because churches are exempted, but what if you're Houston Baptist University, right here in H-Town, right? Or if you are or St. Thomas, right? Or one of these other places, right? Unclear whether a person could request it. And by the way, the aspect of this law is this doesn't mean that you ask ask a transgender person to use a single stall. It means the general bathroom, shower, or locker room. This will be on the ballot on November 3rd. And if enough people vote no on this, indeed the ordinance will be repealed. Houston has a weird direct democracy where they can actually repeal ordinances that were passed by city council. So this is coming up. So I will leave it there. But the law itself, and I did a podcast on this, so you can find on my blog, does not have particularly strong religious carve out. It's actually fairly narrow. I think it's basically houses of worship and other such religious organizations. If you have a Christian bookstore, that can be covered. Probably not. So it's as the Solicitor General said, it's going to be an issue, which is not much of an answer. I've given a bunch of talks on this topic also. We'll do this when we get to gay marriage, I promise. Any other questions before we get to Brown? Brown's most anticlimactic case I'll ever teach, isn't it, right? How many people, when they read Brown, were all excited, and you were like, is that it? Right? Every time I read this, and I reread every case every year, I'm like, really, is that it? Like the most important case, if you ask some guy in the street, name a Supreme Court case, Brown, right? It's something that people know, right? Maybe Roe or Bush v. Gore or whatever. But this is the case that every school child knows. They're taught that it's the most important case ever. And then you read it and you're like, what the heck is this? Like what a ripoff, right? But I think now you're mature enough to appreciate why the opinion is so narrow, right? They've been threading narrowly for, 50 years at that point. They still did not think that they had the capacity, for lack of a better word, to outright overturn Plessy. So they tried once again to make the ruling as narrow as possible, based on all things social science and how people study better. So let me give you a little bit of, a little bit of the history of the case. So I mentioned that the NAACP was very strategic in bringing cases. They didn't bring a school desegregation case until 1950 whatever, right? They didn't think they were there yet, but the decision was made that, okay, we got to try this now. And they went out of their way, and this is, if you ever do any public interest litigation, right? This is a litigation where you're trying to fight for a cause. The number one rule is pick good plaintiffs. Okay, the number one rule of public interest is pick good plaintiffs because your facts are often helpful. So in this case, they picked this adorable little girl, Linda Brown, who went to Topeka, Kansas high school. And this is actually her family. And by the way, it was no mistake that her name was Brown, like the color. This wasn't an accident. These were smart people. They wanted a case to actually resonate, and the name of the case would be remembered. This wasn't inadvertent. Hold on. There were, let's see, 1, 2, 3. There were like 6 kids, right? They picked Linda Brown deliberately because that way people can remember the case. So they picked people, black families in various states. What was it? It was Kansas and Delaware. Yeah, Delaware, right? Northern state, Delaware, and I think one other state. Was it which one? South Carolina. Thank you. I always forget the states. And they basically picked one child and their parent from each seat. The kids are really cute, and they're picking them so they can put them on the front page of a newspaper and say, like, are you going to tell this little girl she can't go to school? Again, this was a very deliberate campaign. As smart as these lawyers were, they had marketing skills, right? They had marketing skills. They want to pick someone who you put these people on a newspaper. It's like, okay, well maybe we can give a release. So these were the students. This is actually Monroe Elementary in Topeka, Kansas. It's actually a national park. If you ever go to Topeka, you can go visit the school, and it's designed as a museum. And they actually have some of the original signs. It's kind of hard to read. That says a white door, and that says colored. And basically, you have different signs telling different students go different ways. You saw this segregated school. Actually, I dug up some pictures. This is actually a photograph of the black classroom, Miss Edna Vance in 1941 at Monroe Elementary School. You see the teacher standing up in the background. There's another picture. So that was the segregated high school. This is Sumner Elementary, which was the white high school, and it was much closer to where the Brown family lived. And then part of the argument, it seems like silly, but she's like, I want to go to the school near my house, right? It's like the kind of thing a child would say, but it has a lot of resonance because why are they making her travel further for an integrated school when there was a school right near her house that she could go to? Okay. So the history of this case is complicated, and the book alludes to it a little bit. But the case was argued twice. Okay. The first time it was argued, the court was under the leadership of Chief Justice Vincent, who was a Truman appointee. And the court was having difficulty reaching unanimity. The court was very intent on not making this case a 5-4 decision, right? They wanted this case to be 9-0. They wanted to speak with one voice to convey to the entire nation that segregated schools could not stand until, for however long it happens to be. So here's actually the order where they say we're going to re-argue this case. And in the process of having it re-argued, kicked over 1 year, right? The Chief Justice was replaced by Earl Warren. Earl Warren was the governor of California, a Republican, if you can imagine, and he was actually a recess appointment by Dwight Eisenhower. Eisenhower once said that Warren was the biggest damn fool mistake he'd ever made. And this was the supreme Allied commander of Europe, so of the entire World War II. So when he says it was a big mistake, he meant it was a pretty big mistake. But in any event, the case was re-argued. Here's some photographs of the case. And ultimately, they reached a decision that's quite narrow. This is actually an interesting note. It's a note from Felix Frankfurter. And it says, he says, Dear Chief, this is a day that will live in glory. It is also a great day in the history of the court, and not in the least for the course of deliberations that brought about the results. I congratulate you. So the justices were very deliberate trying to get this to be a 9-0 opinion, but in doing so, they had to make it so narrow. They couldn't piss anyone off, because if one guy got pissed off, they'd fracture and make a dissent. And as a related note, if you notice in the Obergefell decision, the gay marriage decision, there was only one majority by Justice Kennedy. I'm not giving anything away. It's a horrible opinion. The way it's written is bad. You'll know what I mean when you get there. But you didn't get any concurring opinion from any of the liberal justices because they said, you know what, let's make one opinion and be done with it. And they evoked the memory of Brown of having a single voice. Of course, Obergefell is 5-4. This is a picture of Thurgood Marshall and James Nabrett and George Hayes. These are some of the lawyers from the NAACP who helped to argue this case. A very important case, and indeed, Janine's almost alma mater is named after Thurgood Marshall, which I guess is a fitting name. This is a very iconic photograph, which I'm sure you've seen. It's a picture of Linda Brown and her mom sitting on the courthouse steps, and the newspaper says, High Court bans segregation in public schools. And it's, again, the NAACP, they were smart lawyers, but they were marketers. This is a picture you put in the front page of a newspaper, right? This was a photo op, right? And this is the image they want to convey, saying, listen, this little girl goes to school. Is that so evil? Like, is that such a big deal? Well, it turned out apparently it was, and we'll get there later. So you have all these headlines, segregation rules. But see this subhead, right? Rule unconstitutional by Supreme Court, date and practice not set. Can you imagine? Can you imagine in 1954 picking up a newspaper and saying, when does this happen? Right? I mean, it's easy in 2015 to look back in time and say, wow, it took a while, but I mean, it was very uncertain. But this is Bolling, Thomas Bolling, who was in the other case. So I want to talk a little about the aftermath of Brown, which is alluded to. We'll get back to the case itself because the case itself is much less interesting than the aftermath. After Brown, there was a movement which is often called the Great Resistance, right? Where openly people said that Brown was wrong. Brown was wrong. In the same way that people said that Plessy was wrong based on their independent judgment of the Constitution, as I talked with Roy earlier and Jared. Here you had people like George Wallace say that Brown was wrong. The Supreme Court doesn't know the best. We decide what the Constitution means. And there's this weird asymmetry, right? Where groups are saying that the Supreme Court's wrong, we're going to ignore it. And now the other group's saying the Supreme Court's wrong, we're going to ignore it. So whenever you think about saying the Supreme Court's wrong, you got to think about both sides of this equation. Now, is one correct, one not? That's based on a normative judgment of what you think is right and wrong. That's not anything in the Constitution. So after Brown, the massive resistance, you had the Little Rock Nine, you had to the federal troops ordering people into schoolhouses. There's also other forms of resistance. So see this here, this patch of cement? Can you tell what that is? Diving board. What do you think used to be here?
Swimming pool.
A swimming pool. So this is a case of Palmer versus Thompson. I think it was in Jackson, Jackson, Mississippi. A court issued an order saying you need to integrate your swimming pool. What did the city do? They literally a cement pond, to quote Jed Clampett, right? They literally filled it with cement. Rather than integrate the swimming pool, they filled it with cement. This was typical of the way that a number of states simply just flouted court orders. This is like, I love this picture because it's such a graphic representation of what happened. We already discussed the Little Rock Nine, where the children were accompanied into the building with federal troops. This is Roll Tide at the University of Alabama. Governor Wallace stood in the schoolhouse doors to block entry of black students. You see him standing there with the state troopers wearing their helmets. So there was a massive resistance throughout the South. You had a billboard saying "Impeach Earl Warren." Right? You had a rejection of the Supreme Court's ruling. And this may make sense of why the court ruled so narrowly. Had they just held immediately that all segregation is unconstitutional and every single accommodation must integrate tomorrow, we could have had a civil war. I don't say that lightly. I mean, we could have had massive insurrection, violent insurrection. I mean, someone mentioned Selma and Bloody Sunday. I mean, it could have been significantly worse. So let's actually go through the opinion itself, which I apologize, but it's boring, right? It's not. It takes a few minutes. So Pamela, you've been patiently waiting, I'm sure. You knew you were next forever. Walk us through the actual court analysis, please, in Brown. I'm sorry, and that's Brown number 1, not Brown number 2. We'll get to Brown 2 in a few minutes.
We're talking about like after the re-argument.
Yeah, after the re-argument, what happens?
Well, the legislators, analyzing the first cases, the court displayed that the court intervened immediately after its adoption, that the courts interpreted it as a society policy that was discriminating against black.
Pamela, is the court particularly interested or concerned with what we may call the original understanding of the 14th Amendment, how the framers would have viewed segregation? Are they concerned about that?
Not so much. I think that
Why not? Why do they not care much about it? They explain why.
because like in 1896 it was Plessy versus.
I'm not talking about 1896. I'm talking about 1868, when the 14th Amendment was ratified. Are they concerned with what the framers thought and how these terms were originally understood in the 14th Amendment? Joseph, what do you think?
They said that they argued it and it was inconclusive.
Okay, exactly. So they go like this. We don't know what they thought. We don't know what the framers' intent was. We don't know how these terms were originally understood. Okay. To be slightly critical, they didn't really do too much homework either. Okay. There's a very robust debate, and it's mentioned in the books in the notes afterwards, about whether the 14th Amendment was designed to eradicate segregation in public schools. So one of the biggest obstacles we have here is this: the District of Columbia schools, over the control of Congress, right? Congress controlled DC. They were segregated in 1868. So to make the argument, Michael McConnell, who was a judge and professor at Stanford now, argues that if you look at the debates after the 14th Amendment, there was a strong sense that schools cannot be segregated. But at best, and law professors fight over this claim very fiercely. So they basically toss aside all notions of the original understanding of the Constitution, right? They say, it's inconclusive. Joseph used the right word, right? So Lee, if they're not looking at the history of the 14th Amendment, what are they looking at? Yeah. What do they say about education?
Well, that it's fundamental.
Yeah, reading's fundamental, right? Reading rainbow, right?
And then the segregation actually describes children of a minority group that education opportunities.
Yeah. So the reason why this decision is so boring is the entire thing is about education. What they basically say is this. Education is really, really significant. The states are denying these black children education. Therefore, it's unconstitutional. I'm only slightly exaggerating. The most famous footnote in this decision is footnote 11. And footnote 11 cites a number of studies, one of which is called the marshmallow study. Anyone know about this? That's about
Study that was headed by David Marshall. And it basically was a sociology experiment on how the psychological effects of skin color.
yeah.
Young black children.
Do you remember the results?
That they have forced them.
Yeah, right. So this was tested a number of ways, right? So one of which was basically showing someone a black doll and a white doll. And which one did they pick?
It always picked the white doll to show I was beautiful.
Yeah, exactly
And
right.
the black doll was ugly.
Yeah. So, I mean, there are all these studies showing that, and I'm not a psychologist, but effectively, people had an identity built in that whites were better than blacks. And the studies show that these segregated schools reinforce these identities in a serious degree. Because, I mean, you had a picture up there. Colored students go this way, white students go that way, right? That affects your psyche, right? That doesn't operate in a vacuum. That changes. So what Warren is basically trying to do is saying because segregated schools impede education, right? And only for that narrow reason, these segregated schools cannot continue. Okay? He does not say Plessy versus Ferguson is overturned. He only says to the extent that Plessy is inconsistent with these educational goals, we do not follow it. Everyone get that move. He does not overturn Plessy. He simply says to the extent that Plessy is inconsistent with these educational goals, we do not follow Plessy anymore. Yeah,
One of the things he said is that whatever may have been the extent of this knowledge, any language in Plessy contrary to this finding is rejected. So he's only rejecting that.
Yeah, and was there anything in Plessy about education?
Right. So he's just sort of targeting just to that.
That's it.
I'm not saying anything about anything else.
Not transportation, not hotels, not restaurants, not employment, just education, which wasn't mentioned at all in Plessy. This is why this opinion, again, seems so anticlimactic. He basically made his opinion so narrow, so threaded, okay, that the only reason why Brown had to be sent to an integrated school was because it impeded education. There is no constitutional holding there at all. At best, it's based on social science. And footnote 11, which lists a bunch of those studies. That's the holding of Brown. I mean, I wish I could tell you more, but that's it, folks. Right? I feel like Elmer Fudd, or is it Porky Pig, right? That's all, folks, right? That's it. Now, let me pose a question that's a little bit provocative deliberately. What if one day we determine that students actually learn better when they're segregated? Whether gender, maybe boys and girls schools learn better, or maybe students learn better in class with people of their own race. Am I crazy?
It's already happened in private school.
Race or gender?
Gender.
What about race? Can you imagine any public school today segregating students based on their skin color? Can you imagine? Can you imagine?
Well, they did I think John Legend did a documentary, and in 2014, there were still high schools in southern Louisiana that had segregated school events like proms.
Yeah. Where are we from? Where's that? It never integrated, you mean? Was that a matter that no one applied, or was it a public pool or a private pool? Private clubs are not bound by the 14th Amendment. Anyone else? So, sure.
I mean, I was gonna say, I played on a college football team. And, they-
Where'd you play?
I played at McNeese State in Lake Charles. And the team, we all got along great together. I got great friends, black and white, off the team. But when we went to eat, everyone just went to the two sides of the cafeteria and ate. Nothing was ever said, but they just naturally seemed to do it.
I was being somewhat facetious, but there was actually a story from Berkeley Law School. And you can Google the story later. But the facts are like this. Various black students in the school complained that when they were the only black student, when the only black student in class, they felt singled out because they were required to be like the token, right? They felt like they were obligated to be the only person speaking behalf of black people. And as a result, they felt uncomfortable. So they actually requested that the school create small sections of 10 students, right? And they put all the black kids in one section. And they said in these small sections, they were able to learn better than in classes where the students were integrated. So the result is you basically have a bunch of all white sections and one or two all black or all Hispanic sections. And the dean of the school defends this, saying that they have studies showing that this is actually good from an educational perspective, that this actually promotes education, that students are not singled out. Okay, Berkeley, California. Yeah, I remember this actually story was yesterday or 2 days ago. I was like, perfect time for Brown. Yeah.
Not to argue with the prestigious school from California.
They don't know what. They're not that smart. Don't worry. You guys know a lot more than they do in Berkeley. Trust me on that one. I go there.
Some of my fellow teachers can back me up here, but we track stuff like that. We had a class that was a kind of a pull-out class just for non-English speaking students from Mexico. Their performances were way lower than every other student that was integrated into regular classes and not pulled aside based on their language proficiency or their identity as a non-English speaker. And I mean, as soon as they were integrated back into those regular classes, their scores on their tests all rapidly jumped up.
I was that child when I was a kid. Grades completely changed when I was pulled back into the integrated system.
Yeah. Anyone else? Anyone else a teacher? I don't know. This is Daryl?
Yeah, same thing. And I teach. I have 5 different high schools. So.
Right. So I'm trying to find this quote from a student.
Yeah, I guess the question I have is, are they saying in this case that the students requested?
Yes.
So it was to accommodate a specific request as opposed to some sort of mandate or some sort of.
Should it matter?
Not necessarily. I'm just trying to understand. I mean, maybe it does.
So one of the issues we'll discuss, Mark, let you in a second. One of the issues we'll discuss later is when using race in affirmative action. Is there a difference between using race to keep black kids at UT Austin versus using race to bring black kids into UT Austin? And one of the dissents by Justice Thomas makes the point that there's no difference between positive versus negative use of race. He says it's racist nonetheless. Mark?
Well, I was gonna say, I think it does matter to some degree, the difference between, a choice and a rule. I mean, I think when it comes down to segregation and things of that nature, it was a law saying that you can't. There must be, separate but equal. And people didn't necessarily have a choice to whether they to make a decision as to whether they were going to be together or apart.
So if they choose to do it, it's okay.
Well, I think if they choose to do it, that's just to me, that's just an unalienable right. It's your own right to choose not to necessarily do something, not that the government should make that choice for them.
Sure.
I mean, I hear what my classmate is saying, but imagine then a group of white students who say, we want to be separate. We prefer to be separate. And I think then it opens up a can of worms.
So what's interesting here, though, and I'll get back to Debbie in a second, is that California is a state institution. They're bound by the 14th Amendment, last time I checked. This is illegal. It's really illegal. And I mean, they're going to get sued. And the fact that they admitted this means they have a record to get sued on. So I mean, we can talk whether it's good or bad policy.
I'll give you actually a personal anecdote. I blew something up a couple of years ago where the California Law Review, so we professors publish on things called law reviews. The California Law Review started requesting the race of applicants submitting articles. And I was like the first person to find out about this, and I blew a whistle, and they stopped doing it afterwards. But they said, well, we don't have enough, minorities publishing with us. So we'll get to affirmative action later. I don't want to dwell on this too much now. But the point I want to discuss is, what if we actually decide or determine that segregating races actually improved education? Does that mean Brown was wrong? Because the decision was so narrow, it was based on this very narrow basis that segregation is bad for education. What if Maricel is wrong? What if, these people have different life experiences, right? Do we reverse it? Yeah. Same? Yeah, that's something.
So, I mean, I think it was great to launch the lawsuit, but there's still something very real in this country about how young minorities identify themselves. So,
And it's interesting that if you read this article later, the students basically are edified in saying that it helps us reaffirm our identity to be like, to be among other people who look like us. And have your hand with it before.
Well, it's very complicated, right? Lots of different facets, no right or wrong. But we're trying to have a more perfect union, right? I just think it's a really slippery slope when you begin to the policy of exclusion, right? It's really slippery. So.
Bill, your hand up?
Yes, let's go back to it more about that choice. I think you mentioned in this article the reason students wanted to separate was because they felt people happening.
Yeah, so let me read you.
So again, it's not they didn't want to be those students if they felt singled out in the class and felt like the token. So I'm curious, instead of just saying, okay, sorry, let us put you in a separate group because you requested. I'm looking at the motivation why they requested it.
So
and I wonder if the school did anything to deal with the issue of who was singling them out, or if it was just this kind of a class-based issue because the professor is
Here, I'll paste the link and you guys can read it later. I'll paste it for the class notes for saying you guys can look at the article. We can talk about it more next class. I was shocked when I read this. It was very surprising. Not the least of which because it's a state university and it's illegal. But Berkeley doesn't usually follow laws they don't like. All right, Nuri and Sophia, and we'll try and wrap up the class. And yeah, 1, 2, 3, go.
What you said about them is they would need someone to be injured before any action could be.
Oh, a white student for being excluded from a section for its first skin color. Very easy. And I'm sure the plaintiff already exists for that one.
The difference between I think that story and Brown is that this is let's say this is an exclusion stating by law that you can't go. While that was asked by the students and more.
Should it matter though?
It should, because that's the reason they're doing better is because they feel more comfortable. If education is supposed to enlighten us and to drive.
So if people request that the Constitution not apply, is that okay?
No, that's completely different.
No, but the people requesting effect would amount to excluding white people from section based on skin color. I mean, but there's a point. If people make a request, does that make it okay? Yeah.
I also remember reading something similar
About what? I can't hear you louder.
Students at like Harvard and Yale, those schools from lower socioeconomic backgrounds. I also remember reading about them doing
Yeah. Actually, Bridget, your hand was up. I'm sorry, I didn't call you before.
That's okay. I was just wondering if just because 10 students felt a certain way, if it's a policy for everybody else from then on, is it really a choice for everyone else coming in?
Yeah, that's why when Nuri asked, it'd be a white kid who's excluded, it would be the plaintiff. And I'm sure, speaking from personal experience, I know who's going to sue over this, and they're going to probably sue very soon. If you know the party, it's not too hard to figure it out. Yeah.
I was just going to say that I think that issue starts at home, and although you're put into situations where you don't have control over the different ethnicities you're around, in my experience, I was always a minority in really different socioeconomic backgrounds than me, like in extreme cases, and it motivated me to work harder to do better. And even though I didn't have the same resources other kids did, it still
I mean, for me, it benefited me, so,
Mhm.
like, extremely, I don't think I would be any.
Yeah, we're going to do affirmative action in a couple weeks. We'll be talking about a case called Fisher v. Texas, which is pending for the Supreme Court. Right now, it'll be argued, I think, in December or so. So it'll be after your exam, unfortunately, which means that we can talk about it more in the abstract.
Let me answer your question.
Yeah, last comment, then we'll wrap up, Brad. Go for it.
I was just gonna answer the question you asked, about should Brown be overturned?
I was asking hypothetically. I'm not asking for, do not put words in my mouth.
Okay. I was just gonna say, I was gonna answer it anyway.
Well, what you'll see is actually in Justice Thomas's dissent in was it Fisher? I can't remember which case. He basically says there's no difference between affirmative action and Topeka segregation policy. Justice Thomas writes very clearly there's no between Topeka's segregation based on race and UT Austin's inclusion based on race. And when we'll get to Fisher in a couple weeks. I promise we'll get there. I got like 6 minutes left. So you want to go for it? Something quick?
Question. I was just gonna ask, you said earlier that it had to be they were going for 9-0. Right?
Yes, ma'am.
So I just was trying to understand, because we have so many cases that are not 9-0, so was there some particular strategy that the court had there, or?
Yeah, so this case was viewed as probably the most important case of the 20th century at that point, because they realized that there would be riots, there would be race riots, there would be lower court decisions, and any sign that there was a difference of opinion, because that's not a legitimate ruling, because the 4 dissenting justices are correct. I mean, go watch a presidential debate and say how 5 justices of the Supreme Court were wrong in gay marriage and 4 were right. Yeah, when there's a dissent, you can say, oh, they were right. When it's 9-0, they can't. Even in Plessy, right? Harlan's 1 vote. It's like, oh, even today, Harlan was right. You can point to Harlan being the other one.
Okay, this is on the holding. Do I have this right, though, that SCOTUS didn't even want to touch that the separate school issue was unconstitutional? They went with the argument that it was counterproductive in education.
It frustrated education, yeah. They say separate education facilities are inherently unequal. Right? That's it. What happens now? The most famous line in Brown is not separate but equal, but all deliberate speed. They effectively say, both in Brown 1 and then later in Brown 2 after the argument, we don't know how to do this. We don't know if we should do this ourselves, but ultimately they decide, let the lower courts handle it. What actually ended up happening was the lower federal courts became supervisors, monitors, if you will, of school districts. And over the course of decades, these judges supervised integration. I am not being facetious. Some of these orders are still in effect today. Federal judges have died, and there are still judges implementing these federal desegregation orders. There's one, I think Louisiana, that was dissolved about a year or 2 ago, right? You still have federal judges supervising desegregation. So let's say all deliberate speed, or that newspaper clip of, what was it? Date uncertain, right? Yeah. Date not set. So like even 2015, there's still certain desegregation orders that are in effect. Yes, there are proms that have white-only proms. Apparently now at Berkeley, they have black-only sections, right? This is not over, and I don't mean to denigrate that in the least. I want to mention briefly in our remaining minutes the case of Bolling v. Sharpe. This is the case that makes this entire enterprise say, huh? So the 14th Amendment says no state shall deny any person equal protection. Great, right? What about this guy? His name is Spotswood Thomas Bolling Jr. What a cool name. He was 12 years old, and he was not allowed to attend high school in the District of Columbia. Is D.C. a state? No, it is not. So because it's not a state, the 14th Amendment doesn't apply to it. They're stuck with the 5th Amendment to the Constitution. Does the 5th Amendment have an equal protection clause? No. Does it have a due process clause? Yes. So what did the court basically say in what can only be described as gibberish? You screamed out. What did they say in Bolling? Yeah, they're just making stuff up at this point, and I don't say that lightly, and I hate to say it, but in this case, they're like, crap. We can't have it that you can segregate state schools, but you can't segregate federal school, but not state school. We gotta make this up. So this is actually called reverse incorporation, right? Reverse incorporation.
The Fifth Amendment's due process clause incorporates, by reverse extension, the 14th Amendment's equal protection clause. Even though the equal protection clause came 70 years after the Bill of Rights was ratified, the framers of the 14th Amendment, not saying so, tried to reverse and bring equal protection into the Fifth Amendment. This is not real. And I don't say that lightly, but this is, I mean, the notes that reflect this. This was ridiculed greatly because there's no textual basis to make this ruling. So we have Brown. The opinion itself did not desegregate schools. It merely deferred to the a lower court supervise it. And then in a series of opinions affecting swimming pools, affecting parks and other places, they one by one, bit by bit, had desegregation orders. But this was not overnight. It was a very lengthy process. Indeed, from Dred Scott to Plessy to Cumming to Giles to Berea College to Brown to today. It isn't quite over. And I suppose date still not set. Any questions? All right. Thank you very much for a very good class. Appreciate it.